Hi, this is Mike from DIY Domination. Have you ever wondered how to secure your assets after your passing? It's a question many of us overlook, but crafting a will and estate plan is a crucial step in ensuring the fruits of your life's work are distributed as per your wishes. Without a will, the fate of your assets could be left to the state's discretion, which may not align with your desires. A well-structured will and estate plan not only protect your assets but also provide a clear roadmap for your loved ones during a challenging time. Over the next few minutes, we'll guide you through a step-by-step process to create a comprehensive will and estate plan. From gathering information on your assets and liabilities, deciding beneficiaries to appointing an executor and more, our guide will equip you with the knowledge you need to secure your legacy. So, are you ready? Let's start the journey of securing your assets for your loved ones. The first step involves gathering all the necessary information. This includes a comprehensive list of your assets. Think real estate, bank accounts, investments, vehicles, and personal belongings. You'll also need to account for debts and liabilities, such as mortgages, loans, and credit card debt. Next, gather contact information for all beneficiaries, executors, and guardians if you have minor children. It's crucial to have this information readily available to ensure a smooth process. Don't forget about specific bequests. These are sentimental items or specific assets you wish to leave to certain individuals. Also, take into account any existing life insurance policies or retirement accounts. These can play a significant role in your estate plan. Accumulating this information might seem like a daunting task, but it's a necessary step in ensuring your wishes are carried out as you intend. With all the information at hand, we can move to the next step. Now, it's time to decide who will inherit your assets. This is a critical step in creating your will and estate plan. The beneficiaries you choose can be family members, friends, even charities or other organizations that hold a special place in your heart. When deciding on beneficiaries, consider the nature of your relationship with them, their present and future financial needs, as well as their ability to manage assets. Remember, you're not just distributing wealth, but also ensuring it's used in a way that aligns with your values and wishes. You also need to decide on the proportions in which your assets will be divided. This doesn't necessarily have to be equal. You might want to leave a larger share to a beneficiary with greater needs or one who has been instrumental in your life journey. Be clear, specific, and thoughtful in this process. Your decisions here will guide how your legacy is carried forward. Once you've decided on your beneficiaries, we can proceed to choose an executor. Choosing a responsible executor is a crucial step in this process. The executor of your will is the person who will manage your estate after your passing. They will handle everything from paying off your debts, distributing your assets to the beneficiaries you've chosen, to ensuring that your final wishes are respected and carried out. Choosing an executor is not a decision to be taken lightly. You need to select someone who is not only trustworthy and responsible, but also capable of handling the tasks involved. It's often a good idea to choose someone who is familiar with your financial situation and your wishes. This could be a close family member or friend, or even a professional, such as a lawyer or accountant. Make sure to discuss this role with them to ensure they're willing and able to take on this responsibility. With an executor in place, we can now focus on appointing a guardian if needed. If you have minor children, appointing a guardian is a step you can't ignore. This guardian will be responsible for your children's care in the event of your untimely death. It's a significant responsibility, so it's paramount to choose someone who is not only willing but also capable of raising your children in a manner consistent with your parenting values. Start by considering close relatives and friends who already have a relationship with your children. It's also important to consider the potential guardian's lifestyle, values, and stability. Once you've made a selection, have an open and honest conversation with this person to ensure they are willing and prepared for this responsibility. Remember, the ultimate goal is to ensure your children's well-being and continuity of care in your absence. This decision is a vital part of your will and estate plan and should not be taken lightly. With a guardian in place, we can now move on to creating the will. Creating the will itself is where your decisions are put into writing. This is where you'll put all the decisions you've made into a legally binding document. Now, there are a few ways to create a will, so let's go through them. First, you've got online will writing services. They're convenient, typically cost-effective, and designed to guide you through the process. They'll ask you a series of questions about your assets, beneficiaries, executors, and such, and generate a will based on your answers. They're a great option if your estate is relatively straightforward. Next, we have the traditional route of hiring an attorney. This is particularly useful if your estate is complex, or if you have specific legal questions. An attorney who specializes in estate planning can provide personalized advice, ensuring your will complies with local laws and covers all bases. Lastly, some jurisdictions allow for a handwritten will, also known as a holographic will. This is where you write out your will entirely by hand. However, it must meet specific legal requirements to be considered valid. If you're considering this route, it's essential to consult local laws and possibly seek legal advice. Regardless of the method you choose, remember that the goal is to create a clear, comprehensive document that reflects your wishes. It's not just about who gets what, but also about how your debts and expenses will be covered, who will care for your minor children, and who will ensure your wishes are carried out. While creating a will may seem daunting, remember that each step you take is a step towards ensuring your loved ones are cared for and your wishes are respected. It's about providing clarity and peace of mind for you and those you care about. Now that you've created your will, let's look at what it should include. But remember, creating a will is just one part of estate planning. There's more to consider, like power of attorney, living wills, and trusts. We'll delve into these topics later, but for now, let's focus on getting your will in order. Drafting your will is where you detail your decisions. Start with an introduction, making it crystal clear that this document is your last will and testament. Then include your personal information such as your full name and address. Next, name your chosen executor, the person who'll ensure your wishes are carried out. Now detail your beneficiaries, who will inherit your assets and what exactly will they receive. If you have minor children, designate their legal guardian. If you're leaving specific assets or items to certain individuals, specify these bequests. Then, outline how your debts, funeral expenses, and estate administration costs will be covered. Are they coming out of the estate, or is there a life insurance policy in place? Finally, sign and date your will. But remember, this needs to be done in the presence of witnesses, according to your local laws. With the will drafted, the next step is to have it witnessed and notarized. Witnesses and notarization are crucial for your will's legality. Let us delve into why. When you sign your will, you're not doing it alone. You need witnesses. This is to confirm that it was indeed you who signed the will and that you were of sound mind while doing so. The number of witnesses required can vary, but typically it's at least 2. These individuals should not be beneficiaries in your will, to avoid any potential conflicts of interest. Now, let's talk about notarization. Notarization adds an extra layer of legal protection. It involves a notary public, a neutral third party, who verifies the identities of everyone signing the document. Not all jurisdictions require notarization, but it's often recommended as a safeguard against any future legal challenges. Remember, the process may seem a bit formal, but it's all designed to protect your wishes, ensuring they are respected and carried out exactly as you intended. With a legally valid will, it's now time to store it safely. Your will won't do much good if no one can find it after your passing. So let's talk about the importance of storing your will safely. After all, a will is a crucial document that outlines your final wishes, and it needs to be readily accessible when needed. One of the safest places to store your will is in a safe deposit box at a bank. This keeps it protected from theft, fire, or other potential damage at home. Another good option is to leave it with your attorney who specializes in estate planning. They will know exactly what to do with it when the time comes. Just remember, wherever you decide to store it, make sure to inform your executor and trusted family members of its location. This way, there won't be any unnecessary confusion or delay in executing your wishes after your passing. Now that your will is safe and secure, it's important to keep it up to date. Life changes, and so should your will. It's a phrase that seems simple, but it carries a lot of weight. The reality is, your will isn't a document you create once and forget. It's meant to be a living, breathing testament to your wishes and should be updated to reflect the changes in your life. Maybe you've welcomed a new grandchild, or perhaps you've purchased a new property. On the other hand, you could have experienced a loss in the family or undergone a major financial shift. All these life events should be mirrored in your will. Aim to review your will every few years or sooner if you've experienced a significant life event. If there are changes to be made, don't hesitate. Your will is there to ensure your wishes are carried out as you intend, and keeping it up to date is essential to that process. With a current will, You may also want to consider creating additional estate planning documents.